Good afternoon, Your Honors. Jeffrey Metz.
Yeah. Do you want to address yourself to the 96 lease governs, correct?
Absolutely does. And Your Honor,
You're not entitled to $100,000 worth of legal fees on a case that you were not the prevailing party, are you?
Judge, we're not, Judge. He's
Would
making,
I just want the answers to that. Am I correct in that?
in terms of.
And he said you extorting them
What,
100
Judge?
grand based on cases that you lost.
Judge, there is, from what I understand, there are legal fees that are part of the charge, but that's not the issue that's before you right now, Your Honor. What's before you right now, as you pointed out initially, is whether a Yellowstone was properly granted. Everything that he's telling you, most of it dehoors the record, by the way, everything that he's telling you can be raised in a summary proceeding, and if they lose, they have the ability to cure. Now, I don't want to.
Why can't we just deal with it in Supreme Court? I mean, housing court is a court of limited jurisdiction. He sort of locks them in a little bit.
Not
Why
really.
in Supreme Court.
Well, Judge, when I was researching this case, it's going back to the legal memory lane for me. Post says civil court. It's the court, limited jurisdiction. If you can determine it there, you determine it there. I went to see, are there more recent cases on that? But there aren't, because that has been the law for the past 30 years. Now, let's just talk for a second about what they can do. First of all, the 2014 lease, that is an irrelevancy that was disposed of in the prior case. We're not relying on it. We're relying on the 96 lease. The 96 lease says that there's a $60 a share transfer fee. So what she can do, very simply, just end this right now, just request to assign, because the lease, the proprietary lease, gives them the right to do that. The will that she says she...
The 96 lease, which
96,
prevents you from
that's correct.
unreasonably refusing.
That's correct. And they said, well, they can't unreasonably refuse. We're financially responsible. Okay, fine. Make the request. Never made the request. The mother has been dead for 3 years. They have never made the request. Number two, have they ever sought to sell the apartment? The answer is no. What they're trying to do, and you see it in the papers, all they've been doing with this thing, Your Honor, is basically using the court to delay everything to time market conditions to sell the unit. That's what they're doing. Now, we can go ahead and let's just be pragmatic about this for a second. You affirm, because I think you should, you affirm we go to housing court. This takes a while. They can appeal it. They have plenty of time to remain in there. There's no reason for a Yellowstone. The rarest of rare occasions when Yellowstones are granted in a residential setting is when you can't cure within the 30 days. This is not a situation like we cite in our briefs where there's an illegal alteration and you're attempting to cure, but you can't get the DOB permits in time. They can cure right now. They can leave the apartment, which they say that they want to sell, that they intend to sell for the highest price, but they're not doing that. And the fact of the matter is, Judge, I don't want to hear about this subletting, because that's just not, it's not, well, excuse me, I'm getting a little.
What's the substantial violation that they need to cure?
The substantial violation is Article 3A. It says...
Of the 96 lease.
Of the 96
proprietary
lease.
lease.
That is correct. You see, they want to have it both ways. They want to say that their family members under the 96 lease, okay, they were when the mother was alive, but they don't want to acknowledge the provision that says when the proprietary lessee ceases to be, you don't have the right to be there anymore. And if you want to go into the merits about this, Judge, it's very clear, because it is actually one of my cases back from 1986. The executor cannot occupy in a residential capacity. That is clear. That is your court saying this. And also, Your Honor, the law also provides that if somebody is in there other than the lessee, the law presumes an illegal subletting or an assignment. And by the way, that is something that's over 100 years old. That's the Mann against Ferdinand Munch case. It was decided in 1919. So, I mean, we have a situation here where the system is being gamed a little bit to time the market. So it's not what a Yellowstone is for. The commercial can't terminate, they can't cure once it's terminated. They can cure. That's what Post is all about, that they can cure. So I would submit to you, Your Honors, that this order, it's a simple order, it should be affirmed. Thank you.
Okay, thank you. Okay.